Hi there, and welcome to the 49th Estate Planning Team. My name is Liz Smith, and I am recording this short video so that you have some introduction to our firm and why we do some of the things we do and how we got started. I am the founder, owner, CEO, and one of our attorneys here, and I will introduce you to the rest of the team. We find this just really helpful so that you have some background about us, but then also I will cover some of the basic foundational estate planning tools to give you some information that we find helpful going into your life and legacy planning session. So thank you for watching. Please watch to the end to get your special code for a discount off your planning. All right. So again, my name is Liz Smith, and I live in Juneau. I've moved here in 2005 with this fellow here, who is now my husband. He wasn't at the time. He did graduate school here. That was before I had gone to law school. So I left, went to law school. I knew I would return to Alaska. And during the way through law school, I decided that I wanted to be a public defender. It took me a couple of years to get hired at the public defender's office. And when I did, I was the only attorney hired in 2012. And the only job available was up in Barrow or Utqiagvik. And I happily went up there to get started as a public defender. I worked there 13 months, but was happy to transition back to Juneau when a position opened up in the office here. When I was in Juneau, I was representing parents when the state takes custody of their children. And I found that to be challenging. I burnt out relatively quickly and then went over to the Attorney General's office as an assistant attorney general there, working with the Department of Health and Social and Human Services, And that was a great job for a while. But along the way in 2017, I became a health coach. And I wrote this book, 30 Weeks to Awesome. So it was in the Fireworks Gallery for a while in Seattle, which was really fun. And through that experience of working as a health coach, I was still working full-time as an attorney. But then I had this little side business and I loved helping people work on their own health goals. But I also discovered that I really loved running a business. After a while, I decided I wasn't so happy with my job. I'd had some other jobs as well along the way. And starting that health coaching made me realize that I really wanted to run a business for a living. And that business itself never took off, but I eventually left the state in 2018 and took some time to figure out what was next for me. I did not think that I would want to work in private practice. I had a pretty negative view of private practice attorneys. For one, I had worked with someone and I really didn't love the hourly billing model. I never knew if I ask a question, if it's going to take a few minutes to give me an answer or potentially hours of research when I'm picking up the bill. And I don't like it on either end. I don't want to bill people to have a conversation about family and weather and the things that one talks about when as humans connecting with one another. And I don't like it as a client. I don't want to do it on the other side either. And then I also knew that I didn't want to work in conflict anymore. So I did quite a lot of hearings in the different jobs that I had had, and I wanted to get out of the realm of conflict. I didn't want to litigate anymore or fight on the other's behalf. So as I was taking that time to figure out what was next, I started thinking about doing estate planning and started what was Liz Smith Law in 2019. And then in 2023, we transitioned our name to 49th Estate Planning to emphasize that we focus on estate planning. That's what we do. At the beginning, I was just trying to see if this was something that I would like to do, and it turns out I love it, and we plan to be here for a long time, hopefully long past myself. So when I started getting into estate planning and learning about it, for one, I talked to people about their experience. I have a friend whose father paid over $5,000 for his estate plan, and his goal was to keep everybody out of court and have things go through a simple process that would avoid probate. When he died, the family was in court for years, arguing with his ex-wife, and it was a pretty nasty battle. My friend said, well, surely that was malpractice, what that attorney had done. But as she looked into it further, she realized that what happened was a really common practice. The attorney had put together legal documents and provided them to her father, and then said, maybe in a letter, go ahead and take these other steps so that your plan will work how you want it to work when you die. And he never did that. There was no follow through in the attorney's office. And so when he died, the plan just didn't work how he wanted it to. And so the couple of things with that, we do everything, as you might imagine, when I talked about hourly billing. With estate planning, we're able to work on a flat fee basis, and we have packages designed for our clients to meet your needs, and then structured in such a way that you can really choose where you want to be on a fee perspective, both from your financial situation and then what you want for your family. And by doing that, it also means that we're allowed to incorporate those other pieces, like what happened to my friend and her father's plan. Instead of just giving you the legal documents, we have a whole team in place that's going to help you do that follow through. And then we're going to review and make sure that it got done, or we even have options to do it for you. And then we also aim to really be your attorney for life. So in this world with lots of litigation, attorneys often take the perspective that we're going to do a representation and then be done and get out. So we don't have that ongoing liability. But we're structured so that if you desire, we're here to look after your family. So for all of our clients, you'll hear more about this, but we do a free review every 3 years, and then changes to your plan would have a fee on top of that. But we also have a family care program or client care program where we are here as your attorney on an ongoing basis for a relatively low annual fee. And that's just to make sure that everything stays up to date so that your plan is actually going to be followed through upon your death. And we'll talk some more about that. When you go through the process, you'll have a better idea of whether that makes sense for you. And we only invite clients to that program that we think would benefit from it. Otherwise, that 3-year review should be great. So that is a little about us and why we're structured the way that we are. Again, my name is Liz, and my hobby is triathlon. And then this is our puppy, Zoli, who, well, he won't be a puppy for long anymore, but that's my family and a bit about me. And then we have a really great team that is regularly growing at this point in time, but this is Gloria on the right. Lower right picture, and she's joined us as another attorney. So if you meet with us virtually, it's likely that you will be meeting with Gloria, and she works from Glen Allen, which is where she is from. So she's a wonderful addition to our team. And then you see most of the rest of us in the picture in front of the glacier. And we have a couple of new team members already. So by the time you are watching this video, we may have even more. But team to support you through the process. All right. Let's see, my slides might be going too fast here, but let's get into talking about what happens to your stuff when you die. So that plan, if you don't have a will or a trust or anything in place to say what happens with your stuff, then the court has a plan for you. Not the court, sorry, but the state has a plan for you, written into statute in terms of what is going to happen. And probably that plan is going to be probate. Probate is a process to transfer assets from your name to whomever is going to inherit them. And it is in court. I think I just mentioned that, but the probate process is handled by a personal representative or an executor, and that individual files in court. And once appointed, they have a tremendous amount of power to gather up your assets and then distribute them to whomever is going to inherit them. If you don't have a will in place to designate who your personal representative will be, or executor, then the law says who has priority to serve. If you're married, that would be a spouse. If you're not married and have adult children, they would have equal priority. So in your case, and if you don't have adult children or a spouse, then some closer relative would have priority to serve. So you can think about in your own family who might be asked to serve as personal representative. And if you have multiple adult children, just as an example, well, they would all have equal priority. So the statute does not say the oldest has priority or the youngest or anything like that. So if with equal priority, if they could decide amongst themselves which of the children is going to serve as personal representative, that's a pretty easy process for that individual to get appointed, at least in Alaska. But if they didn't agree, then they would have to argue in front of a judge, and the judge would decide who's going to be appointed. So that's going to add time and money to the process and expense for a judge, for the hearings involved. Probably a lawyer would be hired for the judge to decide who would be personal representative. And I mentioned under Alaska law, so I also want to just interject a disclaimer here that this information is based in Alaska law at the time of recording this, and it is not meant to be specific legal information for you to rely upon in any way, shape, or form. This is just general guidance and not specific to you. If you would like to work with us, well, you've already signed up to work with us. When we meet with you individually, we will be talking to you about information specific to your own plan based on your assets and your family. And there you can rely on, but don't rely on information in this presentation, please. So probate itself can be expensive. Not everybody loves the idea of it. It usually takes 12 to 18 months to go through the probate process before assets are going to be divided amongst whoever will inherit. There's a lot of fees represented in this slide that go into that are involved with probate. And then where are your assets going to go if you have no plan in place? Well, the law has a plan for that as well. And if you are, just to give you some idea of what might happen in your situation if you don't have a plan in place, if you're married and have children from a joint children for both of yours, then assets go to the surviving spouse and then to the children. But if you are married and have a child or children from a different relationship than your spouse, then your spouse has a right to inherit some assets, and then your children likely will inherit something as well at the time of your death. Not everything goes to the spouse. And then in my situation, I'm married, I don't have children, and my mother is still living. So if I died without a plan, then my mother would inherit some of my assets and my husband would inherit the rest. Or it's actually the other way around. Husband gets a portion off the top and then a percentage, and then my mother would get a percentage of anything that I leave behind. And I will tell a story about my mother later, but that is not who I would want to inherit. So that just gives you some idea of what might be incorporated into the state's plan for you. And then if there are minor children that you've left behind, they would inherit, but they cannot have control over the assets. So a judge will decide who's going to have control, meaning who would make investment decisions and decide how to spend for that child. And then once your child turns 18, they would receive everything outright to do with as they wish. We do have an exception in Alaska. If certain conditions are met, then your family would not have to go through probate. They would avoid that whole process that I just went through. Oh, one thing I didn't mention is probate's also public, so people have an idea of who's going to inherit what. So if all of these three conditions are met, then your family would not have to go through probate. So first, if you did not own a house or other real property, if the vehicles you own are worth $100,000 or less combined, and if the entire value of assets is $50,000 or less. Now, when we talk about really all of these assets, we're talking about assets specifically that would go through probate because they don't pass in some other way. So when we think about that $50,000 or asset or less in assets, you may have a life insurance policy. You probably have a retirement policy set aside, and those assets you probably name beneficiaries, at least when you set up the account. So that beneficiary designation controls. Even if you had a will saying something else, the beneficiary designation will control over your will. There's some exceptions to that if you got married after creating beneficiaries. So it's always important to make sure that your beneficiary designations are up to date after any major life change or relationship change. But so if you can have $500,000 in retirement passing to your beneficiaries, that would not count in this $50,000 or assets. or less in assets. Usually we're looking at bank accounts for that category. So again, if all three of these are met, there's an easier process in Alaska that is not the full probate. You don't have to file in court. Now, probate can be expensive. I usually estimate the cost of dealing with probate at 1 to 5% of the value of assets going through probate. So this slide is just meant to give an example of what the high-end cost could be. We are a relatively probate-friendly state here in Alaska, so usually costs are less than they would be in some other states. But there's still are expenses that will probably be incurred. And in this slide, we're looking at life insurance and retirement being pulled into probate. That is simply to show because if you have a minor named and the minor can't, the company holding the retirement is not just going to write a check to a minor, so that kind of pulls it into probate. If you don't like the sound of probate, you think you're looking at things and think your family would be subject to probate and you don't love the idea of it, even having a will does not avoid probate. Many people think that it does, that if you have everything laid out in a will, then it just happens automatically, but it doesn't. Probate is the process to deal with the will and distribute assets. A fully funded living trust does help avoid probate. Well, does avoid probate, not just help, but we'll talk some more about what it means to be fully funded. Before I get there, let's talk about estate taxes. So many people are concerned about what your children will pay in terms of tax upon your death or other beneficiaries. And so some states have an inheritance or an estate tax, and that's just a tax on the overall value of assets when you die. Alaska currently does not have an estate tax, but we are subject to the federal estate tax. There is always some threshold amount, however. If you die with assets below that amount, then you don't have to worry about paying estate taxes. And when we talk about estate taxes, we're talking about all assets that someone is going to inherit. So even those, you could have a multi-million-dollar life insurance policy that pays out to someone, but unless it was set up in a very specific kind of structure, that is going to be considered part of your estate and potentially subject to estate taxes. So currently, as of, so I'm recording this in 2024, and our current estate tax exemption amount is 13.61 million. That will increase in 2025. And then in 2026, if the legislature doesn't act, there is a sunset clause on the way this law was written for the estate tax that will bring it down to 5 million indexed for inflation. So something to be on the lookout for, but for many people that they're really not concerned about estate taxes right now. As of the date of recording this, people are really starting to talk about that sunset and different planning. But just for you to be aware of estate taxes, we can talk about when we meet where you might, whether that's something you might want to worry about or not with your planning, and what can be done about estate taxes. At least you want to know what's coming. It's a very high tax rate if your estate is subject to estate taxes. So other than that, general inheritance is not taxed. Those retirement accounts that you invested pre-tax, like a 401k or an IRA, you will pay income tax when you take that money out. And if anything passes to your beneficiaries, they would as well. So if you want to take control and put a plan in place, the basic foundational planning tools include a will and also a living trust. So with the will, most people are familiar with what that is. It's a document that allows you to indicate who you want to be your personal representative and who you want to inherit, and potentially when or how you want them to inherit. So through that, a will allows you hopefully to help keep your family out of conflict, because if you have multiple children in that scenario and they all would be potential personal representatives, by designating who you want to do it, then they're not going to argue over it. And hopefully with your stuff, you'll keep them out of conflict as well. Because of that, you have more control with a will. It's certainly a great tool if you're not going to face probate anyway based on your assets. Could face probate. And then a will's our legal mechanism to name guardians for minor children. So you can designate who you would want to raise children if you're not able to do it yourself. So that's the benefits of a will. A living trust is an agreement, and it's sort of an entity if you think about it, and you can transfer assets to a trust. And the real point of doing that is that you keep everything out of court. Because assets get titled to the trust, they're not in your name. So if you recall, I said probate is for assets in your name to be distributed to whomever's going to inherit. With a trust, you can keep your family out of conflict and out of court. Sometimes, and this really depends on the assets you have and then also what you want to happen upon your death, but sometimes a trust tool gives us more flexibility to pass on assets. With a trust, there's 3 different categories that I'm going to talk about that are really testamentary trusts, sort of. They're trusts that get established truly after you die. So sometimes these trusts can be done through a will, but sometimes you really need and usually want to use a trust initially to create these trusts after you die. And that just has to do with how we get assets into these later trusts. So first is that you can ensure your children are not going to inherit outright when they turn 18. If you want to name a later age, you can choose to do that through planning. And then if you want to give to somebody, but you are concerned about their money management skills, now this could also be because of age, or it could be substance abuse, potentially mental health. Now, if someone's on government benefits when it comes to any kind of disability, then we wouldn't want to we'd use a special kind of supplemental or special needs trust. But for someone who just you're concerned about their money management skills, then you can use kind of more of a general needs trust for them. So I said I would tell a story about my mother, and that is a good point to tell it with what you can do with a type of trust for someone. So my mother got very involved in drugs and alcohol when she was in high school. And she was able to hold things together pretty much. She continued using drugs even after I was born, but she held a job and kind of kept things together and was certainly a part of my life. But then when I was in 1st grade, her parents died. I think they were modest, middle-class family, but they left her everything in their inheritance outright. She was an only child. And she decided it'd be a good idea to sell everything and move to Oregon, where she bought a house and another property. And for 14 years, she was unproductive member of society and spent all the money and then got herself into horrible debt and certainly didn't take care of herself physically. So her parents should have known, I'm sure they did know, that she had some substance abuse issues. And what they could have done instead of leaving everything to her outright was to leave assets to her in a trust. And then they could have named someone to be trustee, to manage the money for my mother's benefit. And that person they name could have been a corporate trustee, or it could have been a trusted friend. And that person would have the responsibility to make the investment decisions and decide how to spend. And they could have provided a lot of guidance for the trustee or not. They would have had the choice of what to do. So they could have said that they really want to make sure as long as she can work that she has a job, otherwise she will not get distributions. Or they could have said they don't really care if she has a job, but they want to give her housing regardless. They could really set as many restrictions or as little as they wanted to, but that would have been a way to protect her from herself. So, and the good thing about the planning is you get to decide whether you want that kind of control or not. And then on the flip side of things, you can also provide asset protection for beneficiaries. So you might want to leave money to someone who's really responsible with their money, but perhaps they are in a profession that is subject to lawsuits, like a physician or an attorney, or just anyone is potentially subject if you're in a car accident or something like that. So you can leave assets to your beneficiary and provide a shield around them so they wouldn't be subject to payout if they do get sued. And then the second aspect is with the asset protection piece is protecting in the event that your beneficiary were to get a divorce. So by leaving in a trust, you can make sure assets would not be subject to the divorce. All right, so what about incapacity? If you could not make your own financial or healthcare decisions, we can help you put documents in place of how a financial power of attorney and a healthcare directive, so you can name who is going to make decisions for you. And that's a relatively easy process. And if you don't do that, once you turn 18, no one can automatically make decisions for you. So if something happened and someone did need to manage finances or healthcare decisions for you, that someone has to go to court and be named guardian to do that. And that can be a long, lengthy process. It could potentially be expensive to be named as guardian for somebody. And then it also means there's court oversight ongoing. So a guardian has to file in court every year how they've spent money for the person that they're managing things for. And then the court will send out a visitor every 3 years. So it just adds, it can add a lot of hassle, I guess, for lack of a better word, to a family that you could avoid by simply naming who you want to make decisions. That also means you have choice, of course, right? So you're deciding who's the best at a given time rather than family making that decision. And then just a couple things you might want to think about when you think about planning is if you have minor children, making sure that you have someone local named as a short-term guardian. We do that in our office called the Kids Protection Plan. Without that, it's very possible, even if you've named guardians in a will, especially if guardians are out of town, but there's going to be a period if you were in an accident, for example, and have young children at home with a babysitter. Once the babysitter calls police, if you don't make it home because you're in an accident or even, there's a lot of things that could happen there. Police are really going to have little to no choice but to put your children in protective custody until things get sorted out. So we work on a short-term guardian nomination instead. So you at least have something documented and make sure that that's available to the right people, saying who you would want your kids with to avoid them being with, the idea is hopefully they can be with someone that they know and trust in that really hard situation rather than a stranger and someone you know and trust. And then we have a unique opportunity in Alaska for married couples who have assets that are highly appreciated. When an individual dies, assets get an adjustment in the cost basis. So if you think about if you've bought an asset for $100,000 and then sell for $500,000, you may be subject to capital gains on the growth in value. If couples own property together, there's some different rules about how that basis adjustment comes into play when one dies. And we can make it more advantageous through a community property agreement. So it's a complex topic that we will cover if it makes sense for you when we go through the life and legacy planning session with you, and we'll explain it in more detail. But it can be really helpful. So I just like to mention if you are in a stable relationship and have assets that are worth a lot more than they were that are jointly owned, like a brokerage account or property, then it's worth us having that discussion and going into more detail about this idea of a community property agreement. And then at some point, it might be important to think about your long-term care planning. And we will be happy to have that discussion with you. One of our main plans is to protect assets should you need long-term care. And there's some different, there's things we can do if you are in a nursing home now, or you know someone who is and they're spending down a lot of resources. Sometimes we can protect assets instead, but then you can also do some pre-planning further ahead. So we're here to walk you through that if that's a discussion you would like to have or should have. That slide is in the wrong place. And then when we think about protect or assets and what's going to happen to them, I think it's also a great time to think about, well, if you're not here anymore, how do you pass on those values that you've developed over your lifetime? How do you share stories about your life, or even stories that you know from that have been passed down from other generations? So as part of our practice, we do offer a legacy interview. That's a Zoom recording to share those stories to pass on with a nice recording. And whether you use our services or not, I encourage you to think about what you might want to pass and how to do it. Some people write a life story, and there's a lot now of different options out there to participate in. And there we go. That was the best slide. I don't know if I can go back, but I'll just cover what it's like to work with us, whether you are, what it's like to work with us. So here's our team, both serious and fun here at 49th Estate Planning. So if you're watching this video, you should have already booked your appointment, and we look forward to meeting with you for your life and legacy planning session. That's the appointment we're talking about here. You should have received or will receive a packet in the mail. That's your pre-meeting packet, and that just introduces you some more, gives you some more information about us in that pre-meeting packet. We ask before your life and legacy planning session that you fill out an inventory. You should have received a link to be able to fill that out online, or if truly needed, we can offer a paper copy as well. And we ask you to fill out in as much detail as you're able. We don't need to know everything at this point. Some people don't want to share values. That's fine. What we're trying to do is help you in that life and legacy planning session understand what's going to happen if upon your death. And to do that, we need to know what assets there are and how they're titled, at least in order to walk through that. So that's the purpose of the inventory. And many of our clients find that it also helps them just get financially organized by going through everything through that inventory process. At your life and legacy planning session, you'll meet with either myself or Gloria, or by the time you're watching this, we may have another face as well, another attorney on the team. And you'll meet with us and we'll walk you, well, we like to spend some time at the beginning, just getting to know you and your family. That's a really important connection to have if we end up working with you and designing your plan for you. And then we like to cover what's going to happen now if something happens to you, and then really explore with you, what is it that you want to happen? How do you want things to transpire with your family members? And how do you want people to receive assets? What's most important to you? And then we'll help guide you in what plan might be the best for you. That life and legacy planning session is scheduled for 2 hours. And if you decide that you want to work with us, usually the intro takes maybe 40 minutes to an hour or less, 30 minutes to an hour. And then after that, when we look at different plans, if you choose one and decide you want to work with us, then we will design your plan in that life and legacy planning session. If you're not ready at that moment to design, then we can schedule another design meeting, or if you need to think about, there might be other next steps for you. But if you're ready to go forward, we would design in that meeting. And then we do a signing meeting later. At the life and legacy planning session, or when we design your plan, we'll be scheduling a signing meeting so that we can work off of that and get you to that important step of actually signing documents. After signing is when we offer the legacy interview if you're interested. And then we incorporate a third meeting as well. So after signing, you probably have some things to do to make sure assets are aligned with your plan in terms of ownership and beneficiary designations. And then we have work to do to process anything, all the documents after signing, like scanning and doing some other follow-up. So at that third meeting, the binder delivery meeting, we give you the original documents and go through some next steps for you. And then we talk about, at that binder delivery meeting, what is the best option for lifetime follow-up for you, whether that's our standard kind of 3-year mark. We'll you're welcome to come in and just do a free review meeting and see if there's any reason to do updates or if everything looks good. It's amazing what can happen in 3 years in terms of changes. And, you know, so often I see people with just very out of date documents that might be worse than not having a plan at all. So by offering the free review, we hope it takes any barrier from looking at your plan again. And then for clients where it's a good fit, we have that family care program where we are here for you for an annual and ongoing fee, but that's just, we'll always look at assets and update things, make sure everything's in alignment. And if we feel that you're a good fit for that program, we'll discuss that and invite you to join us. And with that, I thank you very much for watching this video, and we really look forward to meeting you for your life and legacy planning session. As a bonus for taking time out of your busy day to watch this video and have this introduction, we will give you $100 off of planning. Just say that you made it at your life and legacy planning session, and we'll make sure to give you that $100 off. So again, and if you have already attended an event, we don't mix. If you attend an event, you don't get double the discount. But if you have not attended an event, then you get $100 off for watching this video. And again, we thank you and look forward to meeting with you.